Well, hello, friends. My name is Stephen Wood. Welcome to the first annual Green Rights and Warrior Lawyers Virtual Academy. I'm the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia on the traditional, ancestral, and unceded territory of the Musqueam people here in Vancouver, in what is now called Canada. This is the eighth of nine sessions of the Academy that we've held over 3 days. We're almost at the finish line. And we are privileged to be joined from Benin City, Nigeria, by the environmental lawyer and 2022 Goldman Prize winner, Chima Williams. As we get underway, I'd like to invite members of the audience to introduce yourselves in the chat and also to turn on your cameras if you feel that you're in a position to do so, so that we can see one another. This is more of an interactive conversation among friends than a one-way dissemination of information via a webinar. So we would love to see everybody be able to share the feeling of the reactions that people are having as people are as we hear from our speakers. The session is being recorded. It's going to be available on the Academy website where you went to register for this talk, and also on our YouTube channel. Chima's talk will be followed by commentary by Dalhousie University law professor Sara Seck, and then audience Q&A. We invite you to post questions or comments in the chat at any time, even starting from the beginning. When it comes to the question and answer period, we can refer to those questions in the chat, or you can unmute yourself and ask your questions aloud, which would make it a more interactive and personable experience. When we finish that Q&A period, after around an hour total, I will turn off the recording and we will shift into a more informal chat kind of mode. We had originally planned, and you may have already seen this, to have people register for a separate informal chat after the main talk, but we found that that's unnecessarily complicated. So why don't we just stay in this Zoom room, assuming that if you had signed up for that after the talk chat session, you're here anyway, so you will just be able to stay. That is the point at which we will have our sort of virtual at the kitchen table informal conversation with Chima and Sara and everyone who's in the room. I'm now going to introduce our commentator today, who will in turn introduce our featured warrior lawyer, Chima. So Sara Seck is originally from St. John's, Newfoundland, and has a pre-law professional background in music. She studied law in Ontario, articled with a Bay Street business law firm, completed a PhD in law at Osgoode Hall Law School, where I had the pleasure to be on her examining committee, and then joined Western University in London, Ontario as a law professor in 2007. 10 years later, moving to the Schulich School of Law at Dalhousie in 2017. She is particularly interested and has published extensively on the relationship between international human rights law, environment, and business law, with a focus on the rights of local and indigenous communities and global South perspectives on sustainable development, especially in the context of extractive industries. So she's published extensively, in particular on legal duties of home states and of multinational corporations in the context of extractive industries. And most recently, considering how lessons from this research, as well as insights from feminist and relational theory, might inform approaches to environmental and climate justice. So it's a delight to have you join us, Sara, and I'll hand over to you now to introduce our main speaker.
Thank you very much, Stefan. I'm speaking to you today from Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq, where we are all treaty people, and this is where Dalhousie University is located. And it is with great delight that I have the opportunity to introduce Chima Williams today. I began my own legal academic journey with a paper, then PhD, inspired by transnational litigation brought by Guyanese plaintiffs in Canadian courts against the Quebec-based Cambior Incorporated and its own mine subsidiary. And this litigation was from 1997. The plaintiffs were seeking environmental cleanup of a mining tailings dam spill that had harmed the livelihoods of those dependent on the river. And even when I finished my PhD in 2007 with Stefan as a prized member of my committee, the idea that a home state court might one day hold a multinational enterprise accountable for transnational environmental harms was very much still an elusive dream. And so it is with great pleasure that I introduce Chima Williams, the 2022 winner of the Goldman Prize, for his work in holding multinational oil giant Royal Dutch Shell accountable in Dutch courts for its obligations as a parent company to prevent oil spills in Nigeria, as well as a finding of responsibility against RDS's Nigerian subsidiary. Chima Williams joined the Nigerian environmental movement in the 1990s as a student volunteer for Environmental Rights Action, an NGO founded in 1993 that advocates for environmental rights in Nigeria. And in 1998, Chima founded the Students' Environmental Assembly Nigeria, the first ever student-run environmental justice group in the country. Now he's the executive director of ERA Friends of the Earth Nigeria and serves as an environmental lawyer prosecuting transnational corporations on environmental pollution cases in Nigeria. Welcome, Chima.
Thank you, Sara. It's my great pleasure to be here. And Akumuni, great to see your face.
We can hear and see you well, Chima, so I think you can go ahead.
Right. Thank you very much. As Sara has introduced me, I am speaking to you from the ancient kingdom of Benin City in the south part of Nigeria, where we have our international headquarters, where I operate from as the Executive Director of Environmental Rights Action Friends of the Earth Nigeria. As already introduced, my journey into environmental justice movement started way back in 1993 when I got in touch in association with the likes of Nimo Bassi, Oronto Douglas, and of course by association, Kensaro Wuwa through late Professor Festus Ai, who was our leader in terms of coming from civil rights background. Of course, I started my activism from the civil rights background, and these started way back from the secondary school. So it wasn't something that just spontaneously happened. It's something that already had started and honed, refined, and sharpened in the invested days. So coming from that background, we started by association and volunteerism, volunteering for Environmental Rights Action Friends of the Earth Nigeria when it was formed in 1993 as an offshoot of civil liberties organization. We tried to look at issues of environment, because way back then, the issue of environment was not as popular as it is now. It was made known, environmental justice campaign was popularized by the activities of late Ken Sara Seck, who is, on me, you can see that. I purposely wore this t-shirt, which is in memory of Ken Sara Seck. And all of us as environmental justice campaigners from Nigeria in particular, and many of us from Africa, owe Ken Sara Seck our understanding and our strides in environmental justice campaigns. And of course, our leaders that took over and tried to redefine the spectrum of environmental justice campaigns, Nimobase, Toronto Douglas, and the rest, some of them still alive, some late. Toronto Douglas is late, but his memory still lives with us. Because for me, as a lawyer, an environmental lawyer for that, I owe it to Toronto Douglas, because he was the first Nigerian to take on environmental litigation. Okay, and all of us now followed. Even when I started Student Environmental Assembly, it was under the guidance of Toronto Douglas. So I owe him a lot in terms of whatever I have achieved as a lawyer and as a Nigerian and as environmental activist lawyer. And of course, the legend who is still alive, mentoring me from 1990 when our paths crossed till date. He remains my mentor. That's Dr. Nimobase, the leading voice of environmental justice campaign from Africa as at today. This rich background prepared me, in environmental justice campaigns and movements. That, of course, as I said, in the 90s, there was nothing like environmental law being taught in the universities in Nigeria. The closest we had was petroleum law, which came around in 1998 or thereabouts. So I never had the privilege or the opportunity of being taught environmental law as a student undergraduate. So whatever I know and I have applied in environmental litigation or environmental law practice is something that through passion, zeal, concern for the environment and citizens' livelihood protection, I was able to prepare myself for. And if I can do it with passion, I think every other person can also do better than me. Because these days, students have the opportunity of learning from the books and learning in the classroom. And then, of course, getting in touch with some of us that never learned from the classrooms, but learned, through the hard way. Okay, so that is it. And we moved because, of course, the issue of the despoilation of the Nigerian environment, especially the Niger Delta, stems from the operations of extractive industries, mostly. And chief among them is the petroleum extractive industry operators, which is led by multinationals. And of course, these days, domestic oil companies are joining the fray. So it's no longer the business of only multinationals, but national, domestic and national oil companies, who have joined the business are not doing better either. So it gives us a lot of concerns. And of course, it's no longer, it's part of history that the first commercial quantity of oil was discovered in a small town called Oloibiri, now in present-day Bayelsa State. Then before the discovery of oil in commercial quantity in Oloibiri, there were small pockets of discoveries, elsewhere in parts of both present Niger Delta and former eastern region of Nigeria, which comprises of what is today called the Niger Delta region, mostly. Now, from the time that oil was discovered and the operations began of the Shell BP, that's petroleum, British Petroleum, it was not unknown to both the government then, which is the government in London, and the oil company BP, that there were problems that would be associated with oil production. When we did a research that led to the publication by Environmental Rights Action and Climate Justice UK, historically we discovered that from the colonial office in London in the 50s, they already knew, for instance, that the issue of gas flaring would be problematic in the future. But they never made any efforts to stem the problems that will come out of that. And of course, all the pollution, the twin pillars of negative impacts, gas flaring and oil spills, were already known as problems that will arise in the future. And these problems was what led to the killing of Ken Saro-Wiwa, when he advocated that his people, his Ogoni people, were entitled to a better livelihood pattern, because the resources that was coming from Ogoni land was enough to make every Ogoni man to live in heaven on earth. And rather than making that come true, the military junta of Abacha, working in cohorts with Shell, went for the messenger rather than going for the message. And today the rest, we say, is history. And Ken, as a prophet, prophesied that he was not the only one that was standing trial. The government and Shell, if they do not come to account, then in the future, they will account. And I think this is where the struggles of those that have followed after Ken has began to yield results. One is that the Ogoni people have stood their ground and stopped oil operation in Ogoniland for so many years now. Two is that the UNEP report on pollution of Ogoniland and steps to remediate and cure the situation as published has given credence that what Ken was saying was true. Yet the report is lying there, and of course the present administration of Nigeria, we must give them kudos for taking the steps to start the implementation of that report, even though the way they are implementing it is not the way the report have envisaged. But better to start something than nothing at all. Okay, so we can latch on that to ask for more. Now, this has been the situation, and following this is the fact that for some of us, we thought that having tried all advocacy patterns, sit-ons, demonstrations, protests, petition writing, and the rest of them, it didn't yield much of the desired result in tackling the environmental situation in our Niger Delta communities. And this is where we decided, first as Friends of the Earth International, during our legal strategy meeting in Durban, 2006, after Environmental Rights Action and Climate Justice UK had supported the community of Iwerikan through their representative, John Agbemre, to bring an action against Shell to stop gas flaring in Nigeria. And that case we started in June 2005. And by November 14th, 2005, we got, because we came under enforcement of fundamental rights, we got a judgment that outlawed gas flaring in Nigeria. But having secured that positive judgment, gas flaring continued. And of course, in showcasing to the world that gas flaring had continued after we had secured a favorable judgment, I led a team to visit the Iwerikan community and visit the Otorogu gas plant in 2008, and I was arrested with my team of journalists and community people at the instance of Shell. So now with that at the back of our minds, we decided in 2006 to try other means, because even when we tried to commit the then Shell MD, Basil Omiyi, and the group managing director of Nigerian National Petroleum Corporation, NNPC, Funshoku Poloku, and the General Company Secretary, Senator Anthony Brown, to prison for disobedience to court order. We got stuck along the line, and the next was that even the files, the case file, disappeared somehow, and a lot of legal gymnastics happened. But suffice it to say that 13 years after, Shell woke up from their dogmatic slumber and commenced the process of appealing against the judgment of 2005. And as I speak today, the case is at the Court of Appeal, sitting right here in Benin City on Shell's appeal. So, having looked at that, we thought the problem is not getting justice from the courts, but the problem is enforcement of favorable judgments when you secure it from Nigerian courts. Because the executive, who operates in cahoots with the multinationals, either fails, neglects, or refuses to enforce judgments that are against the multinationals, even when such judgments are for the interest, benefits of the Nigerian citizens and the Nigerian environment, and of course, will be beneficial to everybody if it is upheld, including the multinationals who operate. So this was the reason behind our decision to, okay, try to challenge the multinationals in their own home countries, where they respect the law, where they respect judgments. So this is what gave birth to our going to Netherlands, which then was the global headquarters of Shell, to bring an action against them for pollution they cause in tiny communities of the Niger Delta. So, of course, we are all now aware of the judgment, of course, resilience, optimism, unity of purpose, okay, is what has sustained and our ability to manage the expectations of the community litigants, because it would have been terribly demoralizing and disheartening when we lost at the lower courts, okay? But because we believed that we had a good case, and there was no reason for us to have lost that case at the lower court, we appealed to the Court of Appeal. And it is interesting to note that the Court of Appeal, sitting in The Hague, almost agreed with all our position. And this is where we are today. And that judgment equally emboldened other jurisdictions, because the judgment of the Court of Appeal in The Hague was delivered on the 29th of January, 2021. On the 12th of February, 2021, the UK Supreme Court delivered her own ruling that was favorable to a tiny Ogoni community. And stemming from that, Nigerian courts have equally given some far-reaching decisions against multinationals, including beneficial to the government of today. And this has been the reality of our time, that collectively, when we pursue using legitimate means, applying the rule of law, using the law courts, though it may take time, but if we persevere, one day justice will be delivered. And as it is, justice is being delivered against the negative environmental footprint and legacy pollutions caused by the multinationals. Not just one, but almost all of them. Hence, today, it is not surprising for us that the multinationals operating in Nigeria are talking of divestment. Okay, and why are they divesting now? Why are they leaving onshore, going to invest deep offshore? Is that real divestment? The answer is no. We've interrogated it. And we understand that the argument and their reasons for divestment, for divesting, are not tenable. They are not. Because one of their arguments is multiple taxation. The other is the operation of oil thieves. And the other one is difficult terrain. So how can it be difficult for you to operate where you have been operating for years and you have finished polluting it? It becomes difficult to operate onshore, but easier to operate offshore, where there will be no prying eyes. Okay, and the people do not have the technical know-how nor the resources to pursue you and chase what you are doing out there. And then you get incentives from the government to invest offshore. And then you talk about divestment. Divestment without cleaning up your mess cannot hold waters. Of course, as lawyers, we appreciate the fact that he who owns an asset has the right to dispose of that asset as at when and how the person likes. But in the circumstances of the operations of the multinationals in the Niger Delta, particularly, they do not enjoy such rights anymore because there are problems that are already on ground, which they must solve before they can leave. We are not saying that if they want to leave, they should not leave. If you cannot operate within globally accepted standards, and then you want to leave, Nigerians will not beg you to stay. Because after all you take is the profit that comes out, and then you leave the misery, the pains, the sufferings, and the killings and maimings for the citizens. We can no longer continue to accept that. You must operate within accepted standards if you want to remain in Nigeria, or if you want to leave, clean up your mess and we tell you goodbye, restore back our environment to the way it was, before your operations, and restitute the citizens for their sufferings and their pains. And then if you want to go, you can go. If you want to stay, you are welcome to stay. We are not saying that multinationals should leave. We are saying you must operate within accepted standard. And if you cannot operate within that standard, you can leave and we'll tell you bye-bye if you have cleaned up your mess. Now, this brings me to the issue of what do we really think should be done? Of course, there are global standards of enforcement. And just as we have crime against humanity under the Rome Statute, we are advocating that environmental crimes should be regarded and developed as ecocide and have the same status as crime against humanity and be integrated into the Rome Statute and defined in its operational mode, so that there will be a global platform where environmental destroyers, wherever they operate, not only in Nigeria, wherever the environment is destroyed be it in Brazil, be it in Ecuador, be it, in anywhere, Latin America, Americas, in the Caribbean, in the UK, in Asia, in any part of Africa, there will be one unified standard of holding the destroyers accountable, okay? And then being treated as criminals. They are, because anybody that kills or whose activity kills another person, for that offends the criminal laws of any nation and should be treated like a criminal. So these are some of the basic things that we think this platform can leverage on, provide a student audience, to interrogate further and make a review and analysis of these and make suggestions. We can all work as a team to push this and see where we take it to. So I think if I have not taken much of the time, I will pause here and of course have Sara, take over and we continue the discourse from there. Thank you very much for the opportunity.
Thank you very much, Chima, for that very interesting and excellent and inspiring talk. I want to pick up on a few threads, I guess, to reflect. I have many questions for you, but I'll try and offer some reflections first and then move into some questions. I think it's really interesting that after you have been involved in transnational litigation that many people see as being successful or as successful as it could be, your message towards the end is now, this isn't enough. We need to be changing the story and moving into the idea of ecocide, treating these harms not merely as environmental harms that are subject to Nigerian law, even as applied by a Dutch court, but rather something different, more serious, more egregious. And I think that's a really important and interesting message for us to think about as we contemplate what the stories are that come out of litigation and actions, because my thinking has been that courts often, and this goes back to my looking at the Cambior decision in the Canadian context in 1997 and sort of flowing from that, there are a lot of stories that courts have told about how something that happens in another country, even though there might be, a transnational corporation that's associated with that court, because the environmental harm happens somewhere else. This isn't a story that's about us as Canadians, for example, right? The spill in Guyana, that's not about Canada, that's about Guyana, and so it's something that's better heard there. Or even if it's heard here, which I think is what happens in the Dutch case, even if it's heard in that home state court, it's not about applying Dutch law. It's about applying it's still Nigerian law that's going to apply, right? And I think in the Court of Appeal decision, at least my sense is one of the really interesting things is where Nigerian law had a gap, it was filled in by UK law in terms of, in sort of some moments, which is also interesting. But the story that the courts sometimes tell is or that home states courts sometimes tell, right, is that this story about harm in Nigeria or Guyana isn't about us in Canada. It's not something that's relevant to Canadians to hear about and to learn about. It's something that's really only for people in Guyana or Nigeria. And of course, my claim and many people's claim has been that that's entirely false, right? To the extent that Canadians have investments in these different multinationals that then operate in other places, it absolutely is a story about Canada as much as it's a story about Guyana or Nigeria. And so telling, I think what's my sense is that when these stories happen, when the cases are sort of successful, it creates an opportunity to have a conversation about relational responsibilities that cross borders, but which courts often don't want us to talk about, and certainly the multinationals don't want us to talk about either. And so my sense is so I guess my question sort of in part is, despite the fact that we have this judgment that you played a big role in getting, there's still a sense that that's not enough. And so what I'd be curious to hear about is what would you wish that judgment to have done, or what might be the sort of outstanding pieces flowing from that litigation that have not been achieved, that should have been achieved. And perhaps that links back to your comments about enforcement. It's one thing to get a judgment, it's another thing to get enforcement. That's even more complicated when we're talking about transnational litigation and how enforcement works. But I think my impression perhaps is by turning to International Criminal Court and the idea of ecocide, you're suggesting that there are other stories that we also really need to tell. And those are that we have to stop treating environmental harms of this nature as being merely environmental domestic concerns, but rather that they're, as you say, equivalent to crimes against humanity. And so those are some of the threads that I took from your wonderful talk, and I'd love to hear any responses, or we can, as Stephan prefers, move to questions. Thank you.
Okay. Yeah, thank you very much, Sarah. That's a very great way of almost like wrapping, my entire discourse and the way forward. Yes, of course, the judgments from the Dutch Court of Appeal and the UK Supreme Court, actually have tried to close up some gaps that exist within the Nigerian legal system, which, though for me, is not a very big gap, okay? Because as I say it, I got favorable judgment to stop gas flaring, which was and still remains the first kind of that litigation in any part of Nigeria or Africa. Let me not say globally. Okay, The issue of gas flaring has not been litigated so much. And I think John Ogbemre's case is the first of its kind in the global scene. It's after that, tying issues to climate change, litigation, began to blossom. Okay, but in terms of operation of oil companies, especially in terms of the negative impact of gas flaring, before John Ogbemre, there had been no litigation. So there was nothing to really rely upon other than the creativity of the legal team and all the scientists, and all the historians and all the medical practitioners that supported the case one way or the other by providing information, evidence to support the case. Okay, so that is that. And of course, also the Dutch case is equally another one, because this is the first time that a Dutch company is being brought to book in a Dutch court for her operations in another country. So it is still equally creative work, both on the part of the judges, on the part of the lawyers, and on the part of everybody involved, one way or the other. So those gaps that have been closed, can be enforced only if we go to court. Okay? And we know that even when we cry in Nigeria that litigation lasts long, the Dutch case lasted for close to 12, 13 years before the Court of Appeal judgments. Okay, so there is nowhere, it shows that there is nowhere justice is delivered as quickly as people anticipate. And of course, in course of this litigation, the Dutch case litigation, all the 4 original plaintiffs are all dead. So what justice, even if it is secured, they are no longer part of that justice. Okay, they fought so hard for. So this is why stepping up to another level of ecocide, okay, which will answer the question for everybody the same way and at the same time, irrespective of the strengths or weaknesses of your nation and the operators. There will be a universal application. And this may help to equally, because if the destroyers know that they can be held accountable as criminals, just as those that have offended the laws and the citizens who are being tried for crime against humanity are treated as criminals and tried and sentenced, not only to fines, but to prison and some to death. If they know that that type of punishment awaits them, even if it is the disgrace that it will bring to the other egos of those operating companies, it will act as a deterrent on them from continuous destruction with impunity and reckless abandon. So this is why I think that that can be a positive step, to like latch on the favorable judgments that have been churned out between 2021 and this year. So it could be a veritable opportunity for stepping up. Thank you.
Thank you very much. I think it's now back to Stefan to coordinate questions.
Yes, thanks to both of you. I hope you will indulge me, but I'd like to exercise my prerogative as host to ask a question of clarification, or at least of expansion of Chima. Can you tell us a little bit more about the judgment that was received from the Dutch court, what kind of remedy was awarded, and what steps do you think can be taken to actually enforce the judgment?
Thank you very much. The judgment, first and foremost, held Shell responsible for breach of duty of care. Okay, and for not doing what they were supposed to do in terms of stopping the spill from occurring, and when it occurred, from stopping it from spreading, and of course, from cleaning it up at when it was supposed to have been done properly, because these were our arguments, okay? And this led to the Court of Appeal ordering for compensation to be paid to the victims too. And of course, for us as environmentalists, for us as campaigners, the most important and far-reaching component of that Court of Appeal judgment is the order on Shell to install a leak detection system, which will mean that if there is any spill, Shell will already know about it and then take steps to stop it before it spreads. And this is the first time in history that such an order has been made. And this is the first time in the operations of Shell that they are doing that such installation, because there is no way they've been able to find an example that they can follow. So, which means it doesn't exist anywhere. So it is the first of its kind, and we are happy to be associated, with that first. And then we throw it open to the rest of the world to ask all the operators to install the leak detection system on their facilities. So for us, these are the critical, aspects of the judgment that we are all very much happy about. And of course, there are other issues that it has addressed, including issues that have not been fully understood within the Nigerian legal system, which is the issue of the operationability of Egaspin, okay, which is an industry packaged guidelines and standards for their own operation that they want to elevate to the statute of law when it favors them, because the Egaspin provides that when it is third-party interference, they should only clean up, remediate, but no compensation. So they lack on that. But our argument had been that Egaspin is no law in Nigeria and cannot operate at the level of a law because it has not passed through the crucibles of legislative scrutiny and legislative processes of law making. So the Court of Appeal agreed with us on that. So that is one gap within the Nigerian law that judgment has equally closed.
And has Shell started to install the leak detection systems or started to pay compensation to the plaintiffs' estates?
Can you take that question again, Stefan?
Has Shell installed the leak detection systems or paid compensation?
Well, we are in a process on the issues. We are in a process, which I am not bound to speak in details about because we are still in a process. Yeah.
Understood.
So when we are through, we'll let the whole world know what we have come out with.
Okay, well, thank you. There was a question in the chat from Carolina about whether the colonial background influences the operation of these transnational corporations. Carolina, do you want to explain your question, or would you like Chima just to try to answer?
Hi, it's just because of this transnational aspect of this litigation, it brings to me this idea that these corporations do not act on specific places as Nigeria and other places with a colonial background in the same way they would act, and as well as these problems with implementation and bringing these cases on the jurisdiction where the operation happens, and how this is linked to a background of colonial exploration in these places, and why, and is it connected with this idea of bringing the cases in the Netherlands and other global north jurisdictions overall?
Okay, thank you very much, Carolina. I think the question itself almost have answered itself, okay? Because the colonial background of these multinationals, drives their operations even up to now, because some of their operational methodologies and ideas stems from their colonial heritage, okay? Where they see the colonies as exploitation grounds to service the colonial administration. So, and this, of course, if we go into history, we'll realize that these have equally governed the type of agreements and arrangements that are made between the multinationals and the countries where they are operating, even up to date, because some of the rules that were instituted under the colonial administration have not been changed. The colonial governments that superintended over the colonies, still strives and tries as much as possible to still maintain that hegemonious hold on the countries that they once colonized, even though we are called independent countries now. Okay, so yes, the answer to the question is yes. The colonial background is what is still leading in the operational methodologies of the multinationals who still, gets the profits of the colonial, empire or colonized entities and repatriate it back to the home countries, which are the former colonial masters. So that is it.
That's quite, yeah, to put it succinctly. There's plenty of time for more questions, but at this point, I'm going to close the formal proceedings with a reminder and an invitation to everyone to join us for the final session of the Academy, starting in just about an hour, with Jacinta Ruru, who is joining us from the University of Otago in Aotearoa, New Zealand, to talk about her experiences and perspectives on the movement for legal personhood for rivers and mountains and other ecosystems in that country. So thank you so much to both Chima and to Sara for sharing their thoughts with us today. Let's have a round of applause, after which Emma will close the recording, but don't leave.